Good evening, class. I chose to compare the U.S. notions of immunity with those of other countries. Uh, Tonight, I want to discuss the Supreme Court case, or excuse me, the Court of Appeals case, Rubin versus the Islamic Republic of Iran. For the purpose of this discussion, I would like to do a few definitions. Foreign state is defined as used includes the political subdivisions of a foreign state or an agency or instrumentality of a foreign state as defined in subsection B. Subsection B states an agency or instrumentality of a foreign state means any entity which is separate, which is a separate legal person, corporation, or otherwise, and which is an organ of the foreign state or political subdivision thereof, or majority of whose shares or otherwise ownership interests is owned by a foreign state or political subdivision thereof, which is neither a citizen of state or the United States, is defined as in section of the U.S. Code 1332C and E of this title, nor created under the laws of the third country. The reason I bring this up is because it's such an interesting case of immunity and whether it can be applied here in the United States and or if it can be, basically taken away. But it's the view of immunity that I'm actually trying to expound upon. Anyway, here we go. So the issue of this case, okay, and this is Rubin versus Islamic Republic of Iran. It's there is the idea was the issue in the case was that whether the U.S. code, the 28 U.S. code, section 1610G provides a freestanding exception to the attachment of immunity, or if it only eliminates Benek's presumption of separate statuses for a foreign state and its instrumentalities. So the issue with this case is that they were trying to prove whether that section, so 28 of the U.S. Code, section 1610G, provides a freestanding attached immunity, except that which allows terror victim judgment creditors to attach and execute upon assets of foreign state sponsors of terrorism, regardless of whether the assets are otherwise subject to execution under 1610. I know it's a mouthful. So basically, this guy, well, actually, I can read it. The petitioner, his name was Jenny Rubin, is one of the 8 U.S. citizens who were injured in a Hamas suicide bombing in Jerusalem, September 1997. Following the incident, Rubin filed suit against the respondent, Islamic Republic of Iran, alleging that the state had provided material support to Hamas. Rubin and co-plaintiffs successfully obtained a default judgment against Iran in the amount of $71.5 million. This judgment, however, was never paid. So, what did he do? Because of Iran's non-payment, it served as a catalyst for years of litigation where Rubin, he attempted to locate Iran's assets in the USA in order to attach and execute on them as a means of satisfying the judgment. He wanted to get the $71.5 million bill paid, and he wanted to use the section 1608G or 1610G to prove that he could execute and nullify the immunity that they had and execute upon their judgment and collect his money. Okay, and so according to this law, he went to look at the collection of Persian artifacts that were in. Let's see, there was one in the Persepolis collection, the Chagha Mish collection, and the Oriental Institute collection that were in the possession of the University of Chicago, and the Hertzfeld collection, which is also in possession of at the University of Chicago and Chicago's Field Museum of Natural History. None of the attempts to collect or seize their property has actually been successful. So, on the flip side, what's the law in the same issue in Iran? Well, upon researching the Library of Congress, I discovered that there's a law in Iran, regarding financial support of terrorism. It says, according to Article 12 of the Law on Combating Financial Support of Terrorism, which is enacted in 2016, the first-degree criminal courts of the Tehran have jurisdiction to try international crimes of terrorism that are committed against the Islamic Republic of Iran, regardless of whether the actions occurred abroad or within the territory of Iran. In this law, there is no specific reference to foreign states. However, Article 12 could be interpreted as lifting the sovereign immunity of a subject foreign state. That means it can be interpreted to remove the immunity for other foreign states acting against them financially if they're supporting terrorism. Okay, so acts on jurisdiction of the judiciary of the Islamic Republic of Iran to try civil cases against foreign governments. Here, this is what it says: the act on jurisdiction of the judiciary of the Islamic Republic of Iran to try civil cases against foreign governments, that includes the U.S., enacted in 2012, provides that in order to combat and prevent terrorism and violations of international law, eligible natural and legal persons may file actions for damages with the Public and Revolutionary Court of Tehran against foreign governments that have violated sovereign immunity of Iran or its officials. It goes on to say that the court must investigate claims and issue an appropriate judgment. The Ministry of Foreign Affairs maintains a list of foreign governments subject to this countermeasure. Governments that assist listed foreign governments in violating Iran's sovereign immunity are also subject to these measures. So, on one hand, the court says, hey, you were damaged in the attack on Hamas in Jerusalem, you deserve to get paid. And Rubin says, hey, I'm going after them because Iran never paid. And according to the law, he said that they owed me, but Iran, as you cannot seize their sovereign immunity says that you can't seize their property in the U.S. just because they owe you money. On the other side, Iran says that if you violate their law, then your immunity is taken away, and it's completely null and void, and not worth its weight in words. So it's just an interesting case that I found that was super interesting, and just an example of how there are very broad differences between the U.S. and the and immunity, notions of immunity, and those of other countries. See you guys later.